Hello, everyone. I wanted to welcome you to our WAITS webinar today. Today we're going to talk about labor and employment law, executive actions, legislation, and the 2015 forecast. I wanted to introduce myself. I am Jenna Ellis, and along with my co-moderator, Dan Titello. And if you have any questions or wanted to ask Pam a question or are having technical difficulties, please do use the chat feature to ask Dan your question. And you do that just by dropping down the bar at the top, pulling up chat, dropping down to Dan Titello's name, and then sending him a private chat. And we'll go over some questions we've received prior to the webinar and then during the webinar for Pam at the end of the session. So with that, I wanted to welcome Pam. She is our featured expert. We're so happy to have her today. Pam Wolf is an attorney and legal analyst who tracks and analyzes labor and employment law issues, court decisions, and trends. And of course, that's for Wolters Kluwer, the Employment Law Daily. So thank you so much, Pam. We're happy to have you.
Oh, the pleasure is mine. I'm really glad to be here today. We have a lot to talk about, Jenna.
You are right, we do. So with that, let's go to an overview of what we're going to be talking about. And as you mentioned, it's jam-packed. So first we're going to talk about executive actions in 2014. We'll move to some federal legislation in 2014, specifically what didn't make it through, and analyze that and get Pam's take on it. We'll move to some state laws and what's important in those state law overviews. Specifically things like ban the box, pregnancy discrimination, paid leave, and Pam will analyze all of that for us, looking forward, I guess, also through 2015 and what to expect. So Pam, then let's get started and have you give kind of an overview of some of President Obama's executive actions for 2014. I wanted to point out with this first one, it's the white-collar exemption. It's been characterized as the most significant. So can you start there?
Yes, I would have to agree that the President's directive to the Secretary of Labor to review and revise the white-collar regulations, and these are the regulations under the Fair Labor Standards Act that govern when employers are relieved of their obligation to pay time and a half for hours worked more than 40 and a work week as applied to salaried employees. If we can flip to the next slide, and this is information that the White House presented, I think, to sort of justify the review and revision. If you note, in 1975, 65% of salaried employees fell below the threshold salary at which employers might be relieved of their obligation to pay overtime. That's a lot of workers. Flip forward to today and you see that only 12% of salaried employees fall below that threshold. According to the White House, the current regulations are outdated and they're out of sync with our current marketplace and with the models of business that are now in use today. Employers are very concerned about this, and for good reason, I think, because depending on how extensive the changes are, it can certainly impact payroll costs at the very least. So those regulations were initially slated to come out, the proposed version to come out in February, and then the Secretary of Labor, I believe when he was at a Senate hearing in the House, said that he expected them to come out this spring. So we should be seeing the proposal literally any day now. If we flip to the next slide, I wanted to point out that President Obama has also prioritized paid leave laws and adding protections against discrimination based on pregnancy. These are two topics that were presented at his White House summit on working families. And I think it's worth noting that the President is also putting funding behind paid leave law development at the state level. So I think going forward, we're going to be seeing a continuing trend of states and localities enacting paid leave laws and also additional protections against pregnancy discrimination. Government contracting was another area where the President was able to take action.
As we talk about that and bring up maybe the next slide with the number of the government contracting executive actions. Well, I know you detail them in the white paper. A number of our attendees have downloaded that, but you know, are these actions, when we're looking at them, it seems like maybe they're President Obama's response to an inaction of Congress. Would you think that's true?
I think that's a fair characterization. The President, as the Chief Executive Officer, cannot himself, make laws that govern private employers, but he can direct changes at federal agencies and also for employers that do business with the federal government. And on your screen you see some of the actions he took in 2014, and particularly with regard to minimum wage increases and protections against discrimination based on sexual orientation and gender identity. These are certainly areas where proposals in Congress have failed to get enough traction to see the light of day. It's worth noting that the requirement that federal contractors disclose past labor law violations during the bidding process, I think came about in part to a report that found some 49 federal contractors who were sort of repeat offenders with very large labor law violations were nonetheless awarded some $81 billion in government contracts in 2012. So, I think we're probably going to see a continuing trend of President Obama taking action in areas where he thinks there should be progress. But again, he's limited to the federal workforce and to private employers who do business with the federal government.
Okay. And so, when we're talking about President Obama's actions, or really, I guess, what we mentioned, the inactivity of Congress, let's look at some key bills in 2014 that didn't make it through.
I think that's a great idea. And if we flip to the next slide, you'll see several areas where there were proposals in Congress that didn't make it through. The first several are targeted to the National Labor Relations Board, which many lawmakers and employers see as being a very aggressive and overreaching agency. So these laws were targeted to sort of rein it in and curb some of its activity. I think generally on both the federal and the state level, there has been a lot of legislative activity that is aimed at sort of blunting union activity. In the states, we see that sort of centered around right-to-work laws and sort of restricting public employee union activities.
Okay.
I think just before we move on, Jenna, I'd like to point out that the Pregnant Workers Fairness Act not only didn't see the light of day, but it really didn't even make it out of committee. And that is an area where Congress failed to take action, but states nonetheless have moved to try to sort of close up the gap in protections against discrimination based on pregnancy. We'll be talking about that a little bit later.
Yeah, and actually that's a really good transition, because when you're talking about, when you're talking about states then, acting and bringing up different initiatives, ballot initiatives, et cetera, I wanted to transition to the states and their actions. As you said, we're going to touch on the pregnancy discrimination, some others, but here's kind of an example of states moving forward when we talk about things like minimum wage, and this is a really good summary here on this slide.
Right, I think it is, and there has been a trend for minimum wage increases in the absence of a federal minimum wage boost. In 2014, a dozen states enacted laws that increased minimum wages, and in another 4 states, there were voter initiatives that succeeded to increase the minimum wage. I think it's also important to note that we see minimum wage increases at both the city level and other local levels. Perhaps the most controversial was a minimum wage increase in Seattle that is going to boost the minimum wage to $15 an hour by 2017. One of the reasons why that particular ordinance is so controversial is because under it, a franchisee can be considered a large employer if the franchisor has more than 500 employees nationwide. And that's a bit of a big deal because if a small franchisee is treated like a large employer under that particular ordinance, the increases, there's a series of stepped increases that come much more quickly. So there's been quite a bit of controversy surrounding that one. I think in 2015 we're going to continue to see more minimum wage increases, at least in the absence of an increase at the federal level. If we flip to the next slide, there were other laws, obviously, that were passed among the states that reached the labor and employment landscape. I think the ban-the-box laws are significant. We'll be talking about them a little bit later. But I thought it interesting that there continues to be a trend where the EEOC's updated criminal history guidance remains very controversial. Several states have prohibited employers from inquiring about criminal history information on an application. That's how we get the name Ban the Box. So we'll be talking about that a little bit later. Another interesting law in California mandated training on workplace abuse, which is really all about bullying. I think this is a slower trend, but I think we may see more laws that target bullying. Of course, those laws have tried to reach schools and other places. The trend to develop employment-related bullying laws is a much slower one, but I think it will continue. States also passed laws governing civil unions, same-sex marriages, marijuana, and pay equity. The same-sex marriage issue is one that has been extremely difficult for employers because it really impacts the way they manage their employee benefits. It's especially problematic for employers that operate in multiple jurisdictions. As many of you know, the consolidated same-sex marriage cases were before the Supreme Court for oral argument yesterday. And I know that everyone is looking forward to the Supreme Court's ruling, which should come out hopefully by the end of January. And I think the ruling will provide much clarity, and there'll be a lot more certainty for employers where right now there's a lot of complexity and confusion. On the next slide, we're back to pregnancy discrimination. And I want to begin by talking about the EEOC's updated guidance on pregnancy discrimination, which was released in July 2014. Many thought that the guidance really went a little bit too far. The major pieces of that guidance were related to pregnancy discrimination under Title VII and under the Americans with Disabilities Act. Switching to the next slide, many of you know that last month the U.S. Supreme Court decided Young versus UPS, which was a pregnancy discrimination case that was brought under Title VII. I think it's really important to note here that the Supreme Court disagreed with the EEOC's position under Title VII, and it's my understanding that the EEOC is going to be revising the Title VII piece of the guidance. However, the other parts of the guidance will remain in place, and the EEOC, as I understand it, is not going to withdraw the entire guidance because the opinion did not impact the rest of it. There's also one important point I wanted to make here. There are some state laws that did in fact track the EEOC guidance, at least in some respects. For example, Delaware. So an employer operating in Delaware needs to be aware of that because it may be easier in that state to prove pregnancy discrimination under state law than it is under federal law. If we can move to the next slide. So why may it be easier to prove pregnancy discrimination in Delaware and other states that may have tracked the EEOC's guidance? Well, because the Supreme Court used a modified McDonnell-Douglas test in analyzing the case. The McDonnell-Douglas framework, of course, is a burden-shifting framework under which the plaintiff must initially provide enough evidence to establish the things that you see on the slide right now. This would be the plaintiff's prima facie case, according to the Supreme Court ruling. And if you scroll down to the last bullet point, you see that the plaintiff is required to show that her employer accommodated others, plural, similar in their ability or inability to work. So the Supreme Court would require more than a single comparator, more than just one non-pregnant employee who was treated differently by the employer. The Supreme Court says not so. So that's a difference that really matters. And if you haven't already read the Supreme Court opinion or somehow from some other source, gotten an analysis of what the court did, you really should do so because the court did modify the McDonnell-Douglas framework in other aspects too.
So if we take, if we think about that and this McDonnell-Douglas analysis and think about these accommodations and we kind of move them over to the states, I think our next slide talks about Illinois, at least, and the Illinois bill, and we have it listed up here. So is this a good example, then, of these kind of accommodations that they were mentioning?
Yes. It's important to note here that pregnancy discrimination can be analyzed under the Americans with Disabilities Act, and there you're looking at accommodating conditions that are related to pregnancy and childbirth. Or it can be analyzed under Title VII, which is a slightly different analysis, and there are slightly different requirements. So the Illinois bill, I think, is really great because it shows the variety of accommodations that employers might have to make for workers who are affected by pregnancy. I'll just toss in here, in addition to Illinois, there were several other states in 2014 that passed pregnancy discrimination laws. Those were Minnesota, New Jersey, West Virginia, and Delaware, the law that I referred to earlier. It's worth noting here that under the Illinois law, employers might be required to provide light duty. That's what was at issue in the Supreme Court case. And employers might also be required to provide temporary transfers or reassignments to a vacant position. On our next slide, I think this is the sort of thing that employers need to be aware of, and it's something to watch for going forward. In Minnesota, the law that was passed included these sort of per se requirements where the employee does not have to have anything from her doctor saying that she needs these particular requirements, and an employer is also barred from claiming that these accommodations would cause an undue hardship. And those accommodations are more frequent restroom, food and water breaks, seating, and limitations on lifting over 20 pounds. So I think we need to watch for this. There may be a trend here where you've got these sort of per se accommodations that employers may be required to provide under state law going forward.
Okay, and then some other trends, and I know you speak about them you detail them in your white paper, but you also discuss these trends of states adopting what you described as the ban-the-box laws, or you talked about it earlier a little bit and described why it was called that. But it really starts, I guess, with the EEOC issuing their own guidance on the use of criminal histories in employment decisions, correct?
Yeah, I think a lot of states have tracked at least some aspects of the EEOC's criminal history guidance. So the ban-the-box movement, of course, bans inquiries on employment applications. Well, that's exactly what the EEOC said in its guidance, that employers should not be asking those questions on applications. And in fact, the EEOC, while it didn't say exactly when employers should start asking those questions, it did say that employers should have at least a good idea of whether or not, based on the applicant's qualifications and experience, they are at least minimally qualified for the job for which they are applying. The EEOC also said that inquiries into criminal background should be job-related and consistent with business needs. Where there's an exclusion, the EEOC said that the exclusion should be a targeted one that is made after consideration of several factors, and that it should also provide the opportunity for an individualized assessment. Perhaps that the employee would have the opportunity to come back and say, no, you shouldn't exclude me because the criminal record that you've got belongs to somebody else, it's not mine. Or listen, I've done a lot since I had that conviction, here's what I've done, I'm a different person and I have a lot more experience and I can be a trusted employee now. I think one important point to make also is that the EEOC's reasons for issuing criminal history guidance and at least the expressed reasons of the states in enacting ban-the-box laws are quite a bit different. The EEOC is interested in disparate impact discrimination, that is unintentional discrimination against African American and Hispanic men who are disproportionately incarcerated compared to the general population, whereas the states seem to be more interested in reintegrating formerly incarcerated individuals into society, giving them the ability to become productive members of the community and reducing recidivism rates.
And I think that that's actually an interesting transition to move to one of our last topics. And when we talk, I guess, then about state motivation, and what the states are doing. I think when we talk about paid leave laws, there seems to be this movement in paid leave as these states' economies improve. And so as the economy in the state improves, these paid leave laws are changing. So what is on the horizon in this area?
Well, let me start here and say that, as probably all of you know, the federal FMLA provides leave to employees, certain employees under certain circumstances. However, it is not paid leave. It is unpaid leave. There is no federal law that guarantees paid leave to employees. We have a situation where the economy has improved, but we also have a pretty large workforce that is comprised of low-wage workers who do not have access to paid leave. This is particularly difficult for working families. So the states have tried to sort of take up the gap and enact paid leave laws. And this is something that, again, we see at the local level. For example, in New York City. I kind of think going forward, something to watch for will be state legislatures that want to control all of the paid leave laws within the state by passing legislation that leaves the job of enacting those sorts of laws to the state legislature, as opposed to localities that may have already passed ordinances governing paid leave laws, so that you may see some conflicts there, you may see some local laws invalidated. But I think that may be a trend going forward.
Okay, great. So Dan, I think that you answered a lot of the questions during, as did I. So if you have any, if you could forward them to me. We did have a couple of questions that came in prior, and I wanted to talk about those then if you have a second, Pam. One of them you touched on at the beginning of the webinar, but the question was, can you discuss changes in criteria used to determine exempt, non-exempt status of positions under FLSA?
Okay, so as I mentioned earlier, this is kind of a big deal for employers. I think the biggest issue may be what the new floor at which employers may be required to pay, may be relieved of their obligation to pay white-collar employees time and a half for overtime. The floor is pretty low. I think it could be substantially raised. And of course, this applies to executive, administrative, professional, outside sales, and computer employees. I think it's possible that the duties tests for those categories might be tightened up. I think what the President certainly is hoping for is that far fewer employees will fall into that category where they can be salaried and not get overtime. The President used the example of a worker who could be a salaried worker and make $23,000 a year, but nonetheless be making less than minimum wage. The idea initially was that these exemptions would apply to, pretty highly compensated employees. So, nobody knows what the proposed regulations are going to say. So it's really sort of the million-dollar question. But I think it's a pretty safe bet that far fewer salaried employees are going to fall into the exemption. And I have to add that I think we may see some congressional hearings that really probe the Labor Department's justification for making whatever changes it does, because I think historically there really has been a lot of pushback against adjustments to these regulations, and they haven't been updated since 2004.
Great. Okay. Thank you so much. And then, Dan, are there any non-answered questions from the chat?
I don't think so. I mean, I'll just add what Jenna said at the beginning. We'll send a link to Pam's paper because a lot of what's on the slide is also detailed in the paper along with the slides. But no, that was the only questions.
Okay, sounds good. And so with that then, I wanted to thank everyone and thank Pam. We really appreciate this. Is such good information. Thank you so much for your time today, and thank you to all of our attendees. As Dan mentioned, you will get an email from us that has Pam's paper. It also has the slides. A lot of you were asking if you could get the slides after. You definitely can. That will be in an email. If you have any questions or any follow-up, my email address is right on the screen, as well as when we send you that email, we're going to send a really, really short survey. If you could fill it out, that would be great. The survey helps us determine topics that you're interested in. So that will be coming in an email later today. So thank you again so much, Pam, for your time and all your expertise. And thanks, everyone, for attending our Wolters Kluwer What Are the Experts Saying webinar on labor and employment law.